and prompt cards with all the fantastic points you're about to make during the course of your session, and slowly and rather laboriously start ticking off all the points that have been made by speakers before you in a much more erudite and better way. So what I want to do is to... Oh, do I? Oh, I probably have. Yeah.
David, I think also David's got 2 mics, so we're going to take this one away from him.
Can you hear me? Yeah. Okay, fine, perfect. I don't have to pretend to be a pop star with the mic. So what I thought as I was going through my list of things and kind of slashing through them, luckily I think the core of what I wanted to say I think remained, which is to really pick on one issue and try and approach the concept, the idea of how we improve efficiency in arbitration through one kind of phenomenon, which I think is actually quite significant, certainly in the London arbitration market, but also in arbitrations throughout Europe. And that's the increased use and appointment of ex-English court judges, and the effect that that's had both for good and bad in the way international arbitration is practiced. And it's quite, I was going back with my firm Skadden and going through the statistics of our appointments, and I was quite shocked actually that we had over 85% of our cases had at least one High Court or Court of Appeal or Supreme Court judge. And in the past 3 or 4 years, I've done 6 or 7 arbitration hearings where we've had at least one High Court judge. And I definitely think that it is having an effect upon how the system is actually working. When High Court judges came onto the scene maybe 10 years ago, they had, I think, to kind of quote Gray and Green, they had and as Sir David mentioned, they had the kind of zealousy of a convert to a kind of monolithic belief system, which is international arbitration. And it was full of promises that they would be kind of more royal than the king in terms of applying the international arbitration approach such as it stood. And the question really is, to my mind, how has that changed? And have they been a force for good, or have they been something where we can learn and improve on, or has it created some kind of difficulties with what might be called an overly court approach? And I know there was discussion about 3 KCs being on an arbitration panel, whether that's a threatening or an intimidating panel. I can tell you, when you've got 3 former Supreme Court judges on the panel, you can times that by a factor of 10. First thing is, I think, in my experience of it, is that in many ways, let's talk about maybe the downsides. I think one of the issues on the downsides is adopting an approach which is influenced by their heritage and their experience, which is fine. But I think the problem arises when the parties don't know that that's what they're getting, and especially if you've got counsel from a European or civil law background. And one of the examples we had recently was with a fantastic arbitrator in a case where I was cross-examining, and the rule that we have in English law about putting your case to a witness, and what does that actually mean? And that's something which people struggle with, even within our system. There was a Section 68 case on that issue a couple of months ago, and there was a lot of erudition about what it actually meant, the rule. And I was finished cross-examining, actually got, for once in my career, a very good answer, which I thought I would end on a high note. And as I was looking around to see the applause from my client, I was asked by this former judge, Mr. Kavanagh, aren't you going to put your case? To which and that just came completely out of the blue, and the whole strategy had been, they were trying to prove their case, they hadn't proved their case, we got the perfect answer on the one live issue, and we were going to stop. And so I thought for about 10 seconds, I thought, well, I better put my case, because if I don't, he will, and I'll have no control on coming back on the answers. And so the other example that I had 3 months earlier is when a counsel KC on the other side suggested at a hearing in front of 3 Court of Appeal judges that we should just adopt the White Book as our rule. And I've told this story, and people think it's an apocryphal story, and it's kind of Kavanagh blarney, but it's actually completely true. And I was so shocked, I actually requested a short break with I said, the transcript writer looks quite tired, perhaps we could break there for 2 minutes, and I will come back and tell you why this is a completely balmy idea. Now, there could have been arguments for all of those issues, but the key thing was not taking the advocate by surprise and understanding that you're playing on all the level playing field and how the arbitration is going to move forward. What are the good aspects of it? I think there's one. I think the one aspect is that most senior judges are very light on reading in, if at all, and they highly favour kind of written kind of submissions, which is anathema to a lot, kind of an opening skeleton, which is anathema to most civil lawyers that I've worked with, both with and against. And you're always faced with that question that one faces when one goes for one's annual checkout with your doctor, when they ask you the inevitable question, well, how many units are you drinking of alcohol a week? And so there's the inevitable, do I tell the truth or do I tell my version of the truth? And when you ask the arbitrators whether they've read the materials, you have exactly the same response. What's the problem with that is that you end up having, it's conflicted because the judges don't seem to go the full way with that and give you more time to open orally. You're crammed in normally to an afternoon or to a morning and split between the two. That creates what I call the kind of cross-examination by opening. And judges continuously criticise the quality of cross-examination in international arbitration and the complete canard of actually putting a document to somebody that they haven't written, which is, of course, is absolutely pointless, but it's done in order to ensure that the key documents are put into the record for the judges that haven't allowed you or the arbitrators to properly develop and show them the documents, and you can never be sure that they've read the documents going in. One thing I think is very beneficial, and I think both, whether you call it civil or common law, and I've seen civil law arbitrators learn and embrace this approach, is to be far less cautious or concerned about intervening in the process to engage with counsel. And I think for me, advocacy is really both opening and closing. All it is an opportunity to engage and prompt questions from the tribunal. So that every time, the best thing that can ever be said to you is, Mr. Kavanagh or Mr. Smith, could you help me with that? I didn't quite understand that part of your case. And of course, that's gold dust because you have the opportunity. And really, in a way, you're laying kind of Hansel and Gretel, like laying crumbs by these interventions with the tribunal that lead the tribunal without them almost knowing to your house in the end of the woods, so that they come round to your way of thinking about the case. And I've seen in the cases where you have ex-judges sitting with civil lawyers that it encourages them to be much more interventionist and less reticent about intervening and really trying to ask pertinent questions in relation to how a party's case should be developed. And that, I think, in terms of, I think we heard about the parties wanting to have a fair crack at the whip, or however you want to put it, making sure that the questions, upon 3 or 4 questions, they've been asked and answered to the best of counsel's ability. I think that's a very kind of important contribution that the judges have given us.
Thank you, David. So is it a fair summary that one of the threats to arbitration is inefficiency, but what you'd like to see is better prepared, more interventionist tribunals? Is that?
Some judges you just know, and we may have heard of some of them, and they say it in there. One of the great things to do is that they love giving lectures, so you can go on YouTube and actually get tremendous insights as they're talking to students at Cambridge or Oxford or wherever it is about how they think and prepare for a case, and they're very much getting into the case to ask those questions. So it's not so much the reading in obviously is to be preferred, but it's more actually teasing out the case from both sides. The only thing I would say on kind of pre-preparation is there's some absolute obvious issues. David was talking about cases where you have the highs and the lows in terms of a quantum. Simple things like agreeing the quantification, the actual valuation date, months before you get into the expert reports, like that could be dealt with in a simple way. But I think kind of reading in and that for the sake of it, where the arbitrator is then not actively intervening or engaging, doesn't really help that much.
Thank you. I know that one of the things Melanie was going to cover is the midstream conference, and I'd be sorry if we didn't touch upon that at all. And I know that Paula has had some experience with the midstream conference, and it does go to procedural efficiency. So maybe Paula, you could cover that for us.
Well, I will try and summarise a few of the points that Melanie was going to make, because I think they were very valued ones. And of course, she's a very experienced arbitrator, and one of her favoured techniques at the beginning of a case is trying to tease out from the parties what their expectations are for the case in terms of procedure, and then suggesting certain things that they might like to consider. One of them is the midstream conference, which can happen after the exchange of memorials or statements of case, document production, where everyone knows a little bit more about what's actually in dispute, and the parties have an opportunity to come back before the tribunal to then perhaps think again about the second half of the procedure leading up to the evidentiary hearing. Now, I think it's an excellent idea, and in fact, in one of the cases where I am sitting as presiding arbitrator, one of my co-arbitrators suggested we do something similar, because certainly at the outset of the case, which is an ICC case, and we've done the terms of reference, but the summaries of both sides' positions were not exactly fulsome. So we suggested a midstream conference. The parties agreed. So after exchange of statements of case and document production, I wrote to the party saying, right, let's organise the midstream conference. And neither side had anything they wanted to raise. We suggested a few things and held on, but it didn't actually prove particularly useful. And I think that's because neither of the parties wanted to engage. They were still exploring their case on both sides. And then a couple of months later, we were met with a stream of procedural applications on both sides, and back to the usual sort of adversarial warfare the parties sometimes indulge in. So all I was going to say is I think it's a great idea. I'm going to persist, and hopefully it will work. And I think Melanie has had good experience with it.
Anya, I can add, please. I can add two elements in terms of efficiency from an ICC standpoint. The first is related to what you're describing as a midstream conference, but quite frankly, it can really just be case management conferences throughout the arbitration. The idea that you have one at the beginning of the case and then you have some sort of call before the evidentiary hearing is based on a time when we didn't use video conferencing and other technology to enable us to get together more frequently. Whether you're under the ICC rules and preparing a terms of reference where you have to address the issues to be decided at the beginning of the case, or in under any other rules, what we're really advocating, and I've spoken quite a bit about this, is to have more frequent case management conferences where you are actually focusing on the issues to be decided more frequently at the case, because under the terms of reference where you are required to do it, many parties are not in a position to actually articulate what the issues to be decided are. So they're at a 10,000 foot level, like the issue to be decided, is there a breach of contract? Or is there a breach of even section 6.2 of the contract? But that in and of itself isn't really getting granular as to what does the tribunal have to decide with regard to whether there is a breach. And so after that first round of submissions, whether it's the statement of claim and statement of defense or memorial and counter memorial, the parties are going to be in a much better position to do that. And it is really, from my perspective, the tribunal's responsibility to get the parties to actually get from the 10,000 foot level down into more granular level to propose and engage with them at that time, so that then when you go into document production, you have an ability to articulate what is relevant and material to the outcome of the case, because you're actually articulating it. I've had parties say to me when I'm sitting, well, this is very difficult to articulate the issues to be decided. You're right, it is difficult, but how do you expect the tribunal to draft their award if the parties themselves can't actually get to that issue. Then before you get to the hearing, you should also be revisiting that list of issues to be decided. And then what I like to do is at the end of the hearing, revisit the issue, engage with the parties, and make sure then the tribunal is going into deliberations with a clarity regarding what actually needs to be decided.
Thank you so much, Claudia. Actually, I'm wondering whether anyone in the audience wants to comment.
Can I just disagree? Can I just disagree about that a little bit? Which is that my experience is that one of the most tedious documents in an entire arbitration is the list of issues documents. And because as you were suggesting, every issue has a series of sub-issues. And it can actually become quite dangerous because you can get the tribunal focused on issues which actually are too granular in the case and kind of shuts off and allowing the case to to develop. And so I think in my experience, I think in a way they become like shibboleths really in terms of as a document that has a kind of life of its own. And ultimately, obviously, you need to kind of synthesize the issues down as you present your case in the hearing. But I think it's probably for each party to deal with that within limits. So I think, in some ways, lists of issues can be a bit of a kind of misleading errand for the party.
We've got lots of people that want to comment on this. So Paula, after you.
I was just going to say very quickly, though, I think it is a good discipline at the outset of the case for the parties to say what they think the issues are at that point in time. So there is some structure around expert witnesses, etc. But that doesn't mean to say it's set in stone. Of course, you've got to revisit before the evidentiary hearing. And as Claudia said again at the end, but I like a bit of structure, David, rather than just, freewheeling through the process.
I think we might have taken all the mics. Guy, do you think you could hand this to Domity? She can go first and then you.
I agree with Paula, but also from the tribunal's perspective, David, this is, from the party's perspective, you get to see at the outset whether the tribunal has understood where the main issues are. It's not set in stone. I find it extremely useful to go through the exercise. I can't stand it when parties say, no, we just put the standard language in issues that may arise, blah, blah, blah. Because this is an opportunity for me to say, this is what I've understood about the case so far. If I'm wrong, tell me. You may change, but at least get the main issues there. And that to me is key. And then the second point, I just want to echo what you said about the mainstream management conference. I call it the second CMC. In my experience, most of the time nothing happens, and I've stopped doing it. I've stopped using it. I first came across it, I thought this is wonderful, but what I've started doing is what Claudia is suggesting. Don't put it in, set a date in stone, but you see issues coming, procedural issues coming, set up a Zoom call. Right. Let's have a call. We block 1 hour. And we get through the issues much more efficient than getting pages and pages of submissions on procedural motions. So I'm all in favour of what you were suggesting, Claudia.
One thing I would like to just say in terms of list of issues would be if it covers quantum issues, please do involve the quantum expert in defining those issues. Almost every time I receive them and they've been agreed before, we've started to get involved. Invariably, there are some basic conceptual things that we might disagree with in terms of how those issues are framed. And there's often talk about experts crossing in the night, and that's really the start of the paths diverging if the issues aren't defined appropriately from a quantum perspective at the start, I would say.
Thank you. Guy, you next, and then Mike. Yep.
Thanks, Anya. One of the things we heard from the GC panel this morning was the idea that actually getting a bit more guidance or a steer from the arbitrators, either in an ARB-MED or a MED-ARB type process, might be really useful. And I wonder whether a midstream conference is an opportunity, possibly, to try and weed out of those memorials those parts of the case which, frankly, a lot of us might read and know will end up getting dropped before the merits hearing anyway, because people focus on it and realise actually they're not going to be able to make out that case with a straight face. Would the tribunal, would the panel be minded to use a midstream conference to go that far, perhaps to try and really pare down what the real issues are in the case?
You're going to your ENE because that's really, I think, what the speakers this morning were hinting at, some form of early neutral evaluation. I think you have to proceed very cautiously, because it really depends how fully the parties have pleaded their cases by that point. But if everyone buys into it and wants some sort of indication from the tribunal, why not? If it's in a plenary session, what I don't think you can have is caucusing. But if it is agreed and everybody's there, and it can be said that this is our view at this moment, but it can't go any further than that.
Thank you. Michael.
Thanks. I agree completely with the comment that many lists of issues go into a level of granularity which just makes them utterly useless. And as a tribunal member, you look at them when you're trying to write your award, and they're going off in all sorts of directions. What we try to do in more recently is actually trying to get decision trees rather than lists of issues. Two different experience, one where it worked brilliantly, one where it failed miserably. Where it worked brilliantly involved the expert. Wonderful accountancy experts who actually produced a decision tree really in the form of a spreadsheet with drop down issues. Tribunal decide issue A, and it goes through and it calculates the damages. And finally, when the tribunal had worked through all the drop down issues on the decision tree, you had your award calculated for you. Great. But when it didn't work was most recently, where we asked the parties to produce their decision trees. We've got 2 decision trees. Doesn't help at all.
Thank you. Anyone else? Yes. You're close to the microphone, yeah.
Thank you. I'd like to say that a list of issues is the panacea to all the woes that we've been talking about all day. We are familiar with the woes of the documents, of the expert evidence and the factual evidence. And the reason that they are woeful is because they don't focus on what is relevant. And the reason they don't focus on what is relevant is because the relevance is relevance to issues, and they haven't been identified. Now, I'd like to put a midstream conference really, really early on, close of memorials, so you can identify the issues, please. The parties move it right back towards the hearing. They don't want to do it. They don't want to do it because it's difficult and it needs input from someone who knows what they're doing. Let's call that person counsel, shall we? And they don't want to do it because they want to keep their options open, because they never know what the documents might throw up. They never know what the experts might say. They don't know what the witnesses are going to say. And it's because they keep their options open that we have all the woes that we have been talking about today.
Thank you, Kim. Alice.
So I have a comment and a question. So I'm civil law trained. So you have the saying, if you can't convince them, confuse them. So in terms of the interim interaction of the tribunal, if you have a second CMC, we tend to be very cautious. And I personally have always the fear that the counterpart gives a loophole and gives the counterparty the chance to confuse the tribunal. So you have that unfair play. So the more interaction you have with the arbitral tribunal, the more you fear that they get confused. So what are your views about it?
As I was saying before, I think that the absolute gold dust is the worst thing you can do is to come out of a hearing with question marks as to have they got the point, or have they understood what you've actually been saying, what you're always trying to find. And obviously, it's most important at the hearing is to try and get the tribunal to tell you what's troubling them, and also really to understand how it's working between the tribunal, because you know that some questions are asked by one member because he or she wants the ammunition in order to have the discussion with the other two, and over time you get that feeling in relation to that. I mean, it really just depends. You have to get the parties at the time that they want to settle. It's like when you try to persuade your children or whoever it is you're trying to persuade, and they're not ready to take the advice or to be persuaded, it's a completely full stop. That's why arbitrators get frustrated because actually the parties themselves aren't at that particular point where they want to settle, and it's as you come down the funnel towards the hearing, that's when it's a little bit more productive to have these discussions. One of the worst things to do is to go off not fully clocked too early in the proceedings, and that's when you have failures, and then you really do stop the parties from coming closer together and try and settle in the case as you go to the hearing.
Okay, I'm going to move us on. Who knew that lists of issues and midstream conferences could have been so controversial? I'm going to pass over to Matt. He's going to talk about techniques for assessing damages and how they're going to evolve in the future. Thank you,
Anya. Okay, I'm going to make 2 points on that, and maybe a third on a related topic involving expert evidence, and particularly valuation expert evidence. So I guess my first point is I really do not think the basic valuation techniques need to change at all. So when it comes to company valuation and associated assessments of loss, the techniques of the discounted cash flow method, the market approach, also the lesser adopted cost-based approach will continue to be used for a long time going forwards. And I would say, frankly speaking, they work just fine for M&A transactions, for financial reporting purposes, for tax reasons, and also generally, in my experience, in commercial arbitration and litigation too. And whilst the DCF approach is often linked to concerns about the size of claims and size of awards in investment treaty arbitrations, I would say those concerns stem, in my view, from misunderstanding and misapplication, rather than any inherent deficiency in the technique itself. Really, for me, as long as the standard for compensation in investment treaty arbitration continues to be fair market value or full reparation, experts will continue to use those approaches, and rightly so, in my view. What I think, though, is changing, and this is my second point, and I think will change at an accelerating rate going forwards, is the toolkit that an expert has at their disposal. And I think that improving toolkit will deliver improvements in efficiency of work, in the ability of experts to provide a more interactive final output for counsel and tribunals to be able to understand the impact of any changes to the factual or legal framework on their assessment of loss. And then thirdly, and I think this is perhaps something that doesn't get as much attention as it could do, the ability of experts to present the results of their analysis in a more visual way. And I think that's an increasing feature of expert presentations, which are often given these days in replacement for direct examination. And I think actually that could also be an improved feature of expert reports, including my own. I'll put my hand up to that from time to time. I mean, on that point, and Michael, this I think is linked to the point you were making before. Who has seen their experts using, just a question for the audience, using data visualization tools such as Power BI and Tableau, and seeing that, for example, in the form of a dashboard that they may be provided with? Is that something people have seen? Okay, a dearth of responses to that in terms of, maybe one or two. And I mean, that tells me that for these tools, which have been around for quite a few years now, there's still quite some way to go before a broad adoption of them. And I think that's relevant when we then think about the impact that AI will have. And I think it's fair to say that, and I would say quite confidently, AI will increase the pace of change in those areas. So it will enable analysis to be performed more efficiently, more accurately, and with greater visual impact going forwards. But despite much of the marketing talk that we hear, I think we also need to be realistic that it might be a few years before we really see the impact of those changes in the output from experts. And then my third point is really just to say I think a change that could be beneficial, particularly for more complex damages assessments, is developing a more in-depth understanding of valuation principles amongst the pool of arbitrators. And I appreciate it's a difficult job and a broad spectrum of issues that arbitrators have to address. But I do wonder if this is an area where aspiring arbitrators of the future could differentiate themselves by being known for being particularly qualified or experienced in valuation and modelling principles. And that's not to say expert witnesses as tribunal members. I appreciate why that might be challenging, but lawyers who have that experience and expertise, I think would be a good point of differentiation of tribunal members of the future.
Thank you, Matt. I did see a couple of hands earlier in the audience. Are there any comments on assessment of damages that anyone would like to make now before we move on? No? Okay. So Matt mentioned AI, and I know, Claudia, that's something that you wanted to talk about. So maybe pass over to you.
I would just address the specific issue of AI in decision making. So we know that AI is being used for analysis of data, is being used to review documents now, could potentially be used for summation of materials. The very specific issue I want to address is, are we imagining an AI is your arbitrator? We know some aspects of AI are being used in courts around the world for even for pre-sentencing elements. And so the appeal, I think we all see from the potential of AI is this opportunity to have a process that is faster and cheaper. And because we all know from the parties themselves that that is what they say they indeed want. So I say this, if all we want is fast and cheap, we could have a coin toss. It would be, in theory, fair. Everyone has the same potential opportunity to be successful. And that is used, for example, to decide who gets the ball or which side of the field or pitch parties or teams may be on. But that is really not going to be a process that we would find acceptable. And then the question is, why not? Why not? What are we looking for? We at core, when we talk about rule of law and access to justice, we've heard it today, we're expecting a level of procedural justice. The idea that somebody's case would be decided, well, 99% of people wearing gray suits have probably committed white collar crimes. Or 99% of defendants are wearing gray suits. You know, we're not going to accept justice based on statistics. We're expecting justice based on our specific case. So could we imagine data being put into a system at some point that would have an element of predictability? Right now we've got issues of bias. We have issues of limitations of data that's actually in existence. We have the black box problem, so we absolutely do not have transparency. We have a whole question of what information is actually going in, and a slew of other issues. That being said, I will say this. When we have backlogs and we have some problems with delay, what level of imperfection are parties going to be willing to accept? And I think we have seen parties make trade-offs between due process and opportunity to have one more opportunity for a submission when they've accepted very expedited procedures in order to have an outcome. And so can we imagine some time in which we're going to have a trade-off that's going to be acceptable? The answer is probably yes, but we're only going to be able to have that if, in fact, we have a system we trust, because that is inherent in acceptance of the process.
That's very interesting. I'm pretty sure that's going to generate comments from the audience. Guy is raising his eyebrows. I know this is one of your pet topics, so Guy.
I'm going to have to just pick a few bits of that because there's so much in it. So, I mean, first of all, there's a mechanism that was referred to actually on the GC panel by Kai earlier, adjudication here in the UK, a statutory adjudication process. That's not perfect, but that has completely streamlined the resolution of midlife disputes in construction projects in order to avoid construction projects grinding to a halt. And actually, that's an interesting example of where a compromise has achieved a desired result, which is actually to get projects done. And Kai raised this in the context of energy transition. And I think that's a really important point, because actually, if dispute resolution slows down processes in relation to energy transition, we're not helping anyone. Let me just deal with the specific AI point. About 10 years ago, I asked a GC, if you could have disputes resolved by a computer, would you do it? And genuinely, I expected the answer to be absolutely not. Without a hesitation, of course. And of course, it's relative. It depends how many cases you have and how much it costs to resolve them and what the net cost of that resolution is versus the outcome. So everything is an economic equation. It's a question of how you get the balance right.
Let me just quickly respond from an ICC perspective, which is that we introduced the expedited procedures in 2017. We've now had 500 of these cases where they're, in essence, automatic application with limited exception for smaller amounts in dispute, now up to $3 million. We have parties opting in to the expedited procedures even when the amount in dispute is over 100 million USD and now even over 200 million USD. That trade-off between additional submissions or the desire for finality is something the parties are opting for. Airbus expressly, will say publicly that they are advocating for that. And so that's something from an efficiency standpoint that if any one of you are engaged in drafting dispute resolution clauses, you're adding the additional sentence, the expedited procedures apply regardless of the amount in dispute, is a way to have that trade-off between predictability of 6 months from the first case management conference that you have an actual award in hand to having additional opportunities for argument. Michael.
I think, Claudia, can I pick up on the really, really fundamental, interesting point that you raised about the difference between statistics and justice? And that's fundamental to the question of AI. And you mentioned AI being used by courts, and you mentioned, I think, pre-sentencing. That you may have had in mind, I think, the study in New York that was done about bail decisions. So a lot of very, very hard-nosed New York criminal judges who made bail decisions every day, their decisions were set up against an AI. And the criterion was basically who absconded. And the AI beat the judges hands down. And the reason for that is that judges are human. They're influenced by people's appearance. They're influenced by the sob stories, even though they're hard-nosed New Yorkers. They're influenced by the sob stories that they're getting. So I ask you this: yes, the AI may be using statistics, but may it not actually be producing a just result that is desirable in any event?
I don't think well, there's a real question about the utilization of AI in criminal cases generally around the world, and Sundaresh Menon, the Chief Justice of Singapore, has raised that as a real question about whether in a criminal context AI would be appropriate, whereas in civil it may be. And I don't know if that line, but we're seeing the utilization of AI in so many other aspects of our lives, and also in by courts, not just in New York, but around the world in different elements of criminal components. And so any judgment, though, is, I think we are, the promise of the lack of bias is appealing. And it could be that it's the swing against the human bias. The question is, and not to suggest that we're being retrograde, the question really is, in what ways do you want your individual case to be considered with the opportunity to bring something both factually and legally that might not have ever been heard before? Because from generative AI, all you have are what's been decided in the past. And so statistical analysis, I think AI is potentially brilliant for.
Last comment from you, Guy.
I just want to deal with this issue of bias because I'm hearing it being used a lot in the context of AI, but let's just get one thing straight. Human beings have bias as well. So we are not talking about perfect human decision making versus bias algorithms. It's probably different types of bias. What is interesting, and I discovered recently, China has already now implemented laws on regulation of AI. So they're ahead of the UK, they're ahead of the US, ahead of Europe, ahead of the UK. IBM has now published its principles on ethics in AI. It has an AI ethics board. There's a lot of work that is now being done in relation to this, and some of the key principles, and you've alluded to some of it, is when you're using AI, an important element of it is to understand the process. So what is the data set that it's using so that you can understand whether there is a risk of bias? How did the decision get made so that you can actually understand and almost reverse engineer the decision making? This is important because it goes to your point, which is about trust in the process, trust in the system. But those things are not beyond the capability of the people who are building these AI systems.
Can we get a microphone at the back there? Thanks, Guy. No, ladies first, if we could pass it right back, thank you.
Sorry, Schopenhauer from, just talking about the AI side of things. I think there's a big difference between predictive artificial intelligence such a wide range, compared to what the recent trend has been over the last 2 years with regard to generative AI and the actual use of those. And as Guy says, you have to really look at a couple of important factors. We're still in that region of narrow AI. So are you talking about courts being using generative AI for decision making? I'm not sure it's really proper decision making that they're using it for. I know that's been an issue with regard to the New York lawyers on using GPT chat in order to find 6 cases, which GPT chat did find 6 cases, and they were real cases, but the actual manipulation of the facts of those did not allude to what was supposed to be put through. Because if you look at the way generative AI is actually being used in ChatGPT, that's one form of transformer model. And that's where you have to really understand the kind of format of how it's actually learning and using the information. And if we look at that, and we can see that how it can cause hallucinations, you will know that the data that or the information that it puts out can actually make misunderstandings. And one of the major important things, I think, at the moment, we are all guinea pigs in the ChatGPT sort of evolution, because at the moment that is open, and anybody who puts prompts or data into that is being used continuously for it to actually rebuild. So if you're using any kind of legal professional privilege or confidentiality information in there, just beware, because it's going out to the public. So that's one thing I think you really have to watch out for, particularly when you're doing mediations, arbitrations, etc. It's good for boilerplate kind of formats, etc., but I would be very careful about how it goes forward. And in terms of bias, I think what Guy said was exactly right. There's 3 forms, not just about the bad data being put in and bad data out, but also about the way that actually it can be used to actually potentiate the kind of bias that we have in society, and also the fact about the programming of the data scientists who actually are programming these algorithms, because that's where they are at the moment. It's a different pool. It's not something like it's open there to actually make decisions. It looks as though it's very intelligent, but it's not thinking like what humans are.
Thank you so much. I'm going to have the last comment on AI because we stole your microphone earlier.
Those were actually points really well made. Some of them I was going to mention as well. Just a counter case study to what we heard earlier about the experiment of the judges. We recently had the case where Amazon actually rolled back their CV screening process because they found that it was actually screening out, and that's an example of black box and bias coming together, because they could not explain how that was happening, and as a result, they had to roll the whole thing back. So one point I was going to make was where, Claudia, you kind of hit a really interesting point where you talked about where parties today are having to make compromises or trade-offs in order to achieve that efficiency. Actually, one big area where AI technology can make that impact is actually help reduce the need for those trade-offs or compromises by allowing you to introduce more efficiency into parts of those workflows. And that's a far more evolutionary and kind of adjacent possible way of approaching how AI and technology can be deployed, rather than this kind of it's great to have the Star Trek type mindset where suddenly you can just have a computer generating all the decisions, but really that takes a long time. In fact, iPad was first featured in Star Trek in 1980, so we saw it 20 years later. So it'll come, but it's going to take time.
Thank you so much. So let's move on to our last topic of the panel. Over to Paula, and you're going to talk about backdoor attacks on arbitration awards.
Yes, I know. So I'm more in the threat mode rather than looking to future new positive developments. So this does assume arbitrators are still going to be required for at least the next decade or so, which I firmly believe that we will be needed for assessing evidence and witnesses. But no, the worrying trend that we're seeing is when an award has been delivered and the losing party is not pleased with the result, they're not only trying to set aside the award or challenging enforcement, they're bringing claims against the arbitrators and even the institutions. So we've seen a couple of recent examples of this. In Indonesia, a Singaporean award was attacked, and both the arbitrators and the institution were alleged to have committed a conspiracy to deceive. That one looked a bit far-fetched, and indeed the Indonesian Supreme Court kicked that out. Indeed, the ICC was involved in a case where there was a decision earlier in the year where luckily the Cour de Cassation threw out a case where brought against the ICC for appointing the tribunal who'd got it wrong. And the French court quite pointed out that the ICC was performing an administrative task and not actually determining the dispute, which was quite right. And let's hope other courts follow in that line. But it has made me think that there's more that can be done to protect arbitrators and the institutions. Now, a lot of the institutions like the ICC and the LCIA, where I'm quite involved, have provisions in their rules trying to get the parties to agree in advance that there should be a level of immunity. But of course, you can only do that so far as the applicable law allows. And then what applicable law are you talking about? Which jurisdiction are you going to be in? Are you going to be at the seat, the domicile of the losing party, where it's being enforced? You don't know in advance. You can't predict what the law will be. So you can only do a certain amount. But I think all institutions could include such a clause and make sure it applies to arbitrators as well as the institutions. I also think a lot more institutions could have rules about the jurisdiction where any claims could be brought. So the LCIA does say the default position is the UK, but actually that only applies to the institution itself, and I think we should probably extend it to the arbitrators too. The ICC could do the same. So at least there is some predictability. But what about the arbitrators? What should they be doing? Now, of course, if you're in an ad hoc arbitration, the arbitrators do think about it, and you get their terms of appointment. They will have some immunity protection in it. There'll be a governing law. There'll be a jurisdiction clause. So that could be dealt with in advance in an institutional arbitration as well, although arbitrators are not very keen on saying to the parties at the first procedural hearing, now, if you've got any claims down the line, is it? But I really do think, given the number of cases that we're seeing, I do think it's something that we should think about in advance, because just at a time when we're trying to deepen the pool of arbitrators, diversify the pool of arbitrators, we don't want people put off because they bear the reputational and financial risk of a claim being brought. Now, of course, there'll be the odd claim that succeeds. There was the Puma case in Spain, where 2 members of a 3-member panel had excluded the third arbitrator from deliberations. Now, obviously, something went badly wrong there, and they had to give their fees back, not much more than that, but hey. But on the whole, these are groundless attempts to upset the arbitration process and the finality of the award. And I think, you know, the more the institutions and all of us as members of the community can do to try to stop that happening by trying to anticipate ways of at least having some predictability about what can happen would be a good thing.
Isn't the problem that it's all about the enforcement court? Because if you London or Switzerland, Geneva or Paris, if you bring that collateral attack on the tribunal, you're going to get pretty short shrift from an arbitration favourable jurisdiction in terms of where the seat is. And it's normally going to the issue is going to come to a head in the home ground of the losing party, where they've got home field advantage, and they may want to bring. I just struggle to see if you're putting in protections, always would sound sensible and would buttress your position in London or in the appeal court in France or Stockholm, or wherever you are in those jurisdictions, or Singapore. I mean, your Singapore example, it was in Indonesia. Yeah. When they went to bring the case against the Indonesian party that had potentially political connections in Indonesia, etc. Didn't fail there, but that's where the problem's going to be.
But if you've already got your jurisdictional clause agreed up front, be it that at the seat or somewhere else, you can't then have people going off. Well, you can let them go off.
Well, but the theory is that they're going.
So I'll just finish.
Yeah, sorry.
But the court that has been seized of the claim should then kick it out, or at least there'll be good grounds to kick it out. But if you haven't dealt with it at all, it's fair game wherever.
And do they, would they respect kind of the limitations of liability if you're going to predicate the collateral attack on fraud? That would be my, obviously every measure, every little bit helps in terms of making sure there's an easy jurisdictional basis for kicking out the claim.
And it's impossible to stop people having a go. Of course that's going to happen. But given the frequency with which these claims are now being brought, I think we should try and limit the avenues to which you can have these, because arbitrators, it's a huge strain on an arbitrator to suddenly find themselves in, Jakarta before the Indonesian court, having to instruct local counsel, paying for all the costs. In Indonesia, costs don't follow the result. So the arbitrators that end up paying all of their own fees. I mean, insurance is another way through, I suppose. Institutions insure. I don't think many arbitrators do. So you'll never be able to rule out everything. But I personally think that we should try and put some safeguards in place. Otherwise, new arbitrators might be completely put off by doing it. Even if it's groundless, if it gets into the public domain that an arbitrator or an institution is embroiled in a dispute where there's a conspiracy to deceive, some other bad faith, bias, it is going to put people off appointing that person until it's sorted out. It might push them towards another institution. It's very unfair.
Thank you, Paula. Claudia, do you have any thoughts on this from an institutional perspective?
We did add in the 2021 rules that claims against ICC must be brought in the French courts, which did create some confusion as to whether that applied to other aspects of challenging the arbitration process itself, different from the seat of the arbitration or something else. But you're right. There are certainly additional cases brought around the world against the ICC, notwithstanding those rules, because parties will try what they can. But we do think that's useful. There is that interesting question about whether there is a possibility of somehow the institutions providing insurance for the arbitrators. And we've certainly heard demand or request, I should say, request from arbitrators that the institutions would actually do that. In other words, of course, arbitrators may have their own insurance, but that there would be a either blanket policy, or if they were serving as arbitrator in an institutional arbitration, that would be covered by a broad policy. So that's certainly something we have explored or are exploring for the future.
Thank you so much. I think we probably have time for 1 or 2 questions to our panel. Do we have any remaining questions? No. Fantastic. Come on. Oh, Guy, all right. I did say last question, but
well, I was going to
last
ask a
time.
question.
Go for it.
It came up this morning about the issue of transparency and confidentiality, and Lord Neuberger identified that having your dispute resolved in a private forum used to be one of the preferred and advantages of arbitration. And some questions have been raised in relation to that, in particular in relation to ISDS. But does the tribunal have a view as to whether transparency is going to be here in, whether confidentiality of arbitral awards will still be here in 25 years' time, or whether we can and maybe should have more transparency over the decision-making process? Because, of course, the other term that Lord Neuberger used was the term respect. And, of course, if you have more transparency of the process, you may encourage more respect of the process.
Who on our David want to say anything about transparency?
I think transparency in the international disputes setting, you can see it just going in that direction, because actually some of the issues that Toby was talking about before lunch, in terms of buy-in to the process from constituents outside the two parties who are arbitrating. And you've seen, I think there was a case with Gabrielle involving Guinea, where they televised or streamed the BSGR iron ore case against Guinea. That was live stream. So if anybody wanted to see a very interesting hearing, they could watch it online. It came down pretty quick after they streamed it. In commercial cases, I think it's going to remain one of the selling points of arbitration, and I think the risk to it is most parties now operate in a much more regulated world. So the common exception is that you're forced to make a particular type of disclosure, and so it ends up being kind of written water, because there's so many ways to drive the coach through the issue. And one would not probably want to see the veil of the sausage making being revealed, because it might be particularly unedifying, but it would open you up to further challenges about the process of the arbitrator's decision making.
Well, I think unfortunately we've run out of time, but so I'm going to thank the panel. But before I do, I was going to ask Claudia, seeing you opened today with a declaration, so I wondered whether you had any final thoughts on the next 100 years before we close the panel.
Well, let me just then close with comments on transparency. Most significantly, there was a recent decision in Singapore dealing with an ICC case as to whether the communications between ICC and the tribunal deliberations themselves were confidential, and as they are expressly stated to be under the ICC rules. And the court did conclude that those were confidential, absent a preliminary showing of a fraud or some other reason where that confidentiality of that deliberation process would not otherwise be respected. So it's not an absolute, but it was a strong decision in that regard. The ICC itself has now publishes reasons for decisions around arbitrator challenges and some other decisions, to basically say, if as opposed to just getting a statement. And so I think that is very essential for an element of our declaration and the future of trust in the process. And obviously we're now publishing anonymized awards if the parties expressly consent in that context. But what we're seeing now is an availability of so many awards because of enforcement or because they're not confidential. But as to whether there is a legitimate expectation of the parties when they have expressly provided for confidentiality that there would be, that's something that ICC respects and will continue to do so. So from a future standpoint, that aspect of legitimacy is essential for us. And so as we're talking about AI and we're talking about all these other elements, I'll just say this. What we imagine arbitration to be in the future is not what we necessarily have right now. And it's relevant to Toby's comments about investment treaty arbitration, but the same can be said for commercial arbitration. So all of us need to be open to new ideas and engaging with them, and the best ideas are not going to come top down. They're going to come from all of you. And so I hope you're thinking creatively outside the box, open to new ideas, and continue to communicate those, because that's going to make sure that we actually have a legitimate process that parties continue to trust.
Thank you so much. Let's all thank the panel.
Thank you very, very much for that. You can stay where you are if you like. Thank you very much. My conclusion I was using 30 years ago at the end of his position, and now by attempted final flourish, and then he went on to give his conclusion. This is my attempted final flourish. Thank you to Lord Neuberger and Claudia for their excellent talks this morning, and thank you to Claudia for being here all day. Not all national committees get Claudia Salomon for the entire day. Lord Villamora gave such an inspiring talk this morning that we'll all be dreaming about tonight, and of course we'll all be now planning our entrepreneurial careers as a result. Remember that luck and determination meets opportunity, and I think there's lots of opportunity today and over the drinks to follow. We had the General Counsel panel where Kai, Kate and Fabio braved a room full of lawyers, again something that doesn't always happen, and that was followed by the great advocacy debate. The point that particularly stuck with me was KC or not KC, that is the question. We'll see how that goes. Then Toby before lunch left us all feeling a little bit unwell for the state of arbitration. The diet has changed, but the knives and forks are the same. And so the question I have is, does it mean that the current system is toast? Mr. Justice Foxton, then after lunch on the approach of the commercial court, he spoke about the toilet habit of bears, amongst other things, which tied today's animal theme together. We had goats on a tether, panther versus a cobra, and then bears in the woods. And then finally, that very interesting debate on the future of international arbitration, covering lists of issues and AI. If all we want is fast and cheap, we could have a coin toss, says Claudia. Others in the room might have different views. Shabana, I think it was at the back, referred to the fact that we are guinea pigs in ChatGPT, which takes me back to the animal theme. And perhaps I should end by saying thank you for joining the conference on promoting the rule of law through animals. Thank you. Our drinks will now be served, I assume, out here.
Actually, no.
No? Okay.
Vista, yeah, we need to go over the footbridge that's closest to the Thames, but you'll have EY people to help you along the way as well, I'm sure.
Great, thank you.